information?
Yes, Your Honor.
Okay. For the appellant, how will y'all do that? Will you have any rebuttal time
We would like to reserve 2 minutes for rebuttal, if it please the court.
for each attorney or just?
2 minutes total, and depending upon how the argument goes, Mr. Lewis may take it, I may take it, and we may split it. We just don't know until we see how the argument goes.
Okay. And on this side, you have a total of 30 minutes, Mr. Patrick?
Yes, Your Honor. It'll be Ms. Ledico and myself making the argument. I'll probably make the primary argument. We don't know how much time we divided the issues up, so it depends on what issues we get to, how much time. So we will discuss it in the argument. But I'll probably.
Okay, sure thing. Okay then, if that's the case, then you may proceed.
Thank you, Your Honor. May it please the court.
Yes.
Neil Thomas from the Hamilton County Bar. I'm here with Mr. Lewis. We will divide our issues. I will speak principally to the issues in this case that resolve around the breach of contract claim by the plaintiff, which is a breach of contract of a buyout provision of an operating agreement of a limited liability company, one member against another member. I will address the two main defenses that the defendant healthcare group had to that claim, both of which were eliminated either before trial or during trial, as I will describe it later. Those issues which constituted the totality of the defense were the defenses of fraudulent misrepresentation, fraud through misrepresentation, and fraud through concealment. I will deal with those two issues separately because they raise different issues in this case. The second issue, the third issue that I will deal with is the issue of accord and satisfaction, and as I will describe later, that defense was eliminated on the second day of trial. If there is time, and I don't know that there will be, there are two other issues that I would discuss, which is the procedural issue associated with the interference claim made against China Beds and the issue of attorney's fees in connection with the breach of contract claim made under the operating agreement. The problem we have, first of all, in arguing this case is that, and I will deal with first the issues of fraud. As I said, there were two issues of fraud. One was concealment and one was misrepresentation. The difficulty I have in presenting an argument with respect to fraudulent concealment is that the motion, the plaintiff early on made a motion for partial summary judgment on the enforcement of that provision. Defendant raised, the healthcare group raised the issue of fraud. That issue was disposed of without findings by the trial court, either findings of fact, and I'm talking about the fraud defense now, not the breach of contract, without findings of fact or conclusions of law. Now, I will say that there was a motion that was made for partial summary judgment that was granted, and a motion to reconsider was made, and that motion to reconsider also involved the issue of fraudulent concealment by a fiduciary. As we have an attorney that's involved in the central portion of the facts of this case, and that motion was decided by a one-page order denying the motion with no findings of fact. I will say that there are no findings of fact with respect to the concealment issue, which I will get to in just a second. There were no findings of fact. We devoted 14 pages of our argument and our appeal to that issue, and there is not one mention of the word fiduciary or this issue in the Appellees brief. Now, what is that concealment? The concealment is this. This case involves the valuation of the buyout provision. The bottom portion there, 5.6, is the provision that was used during trial to evaluate the members' interest in the LLC. And that was contained in the operating agreement. When the operating agreement was drafted, That 5.6 bottom provision was in it, and 5.5B and C was also in the draft. And Mr. Huesman prepared the draft of the operating agreement, which included, the first draft included all three of those provisions on valuation of the buyout. Mr. Huesman then sent that draft to his client, and it shouldn't have been just his client because he was purporting to represent China Bids, which involved the representation of China Bids and both members, but he sent that draft to Mr. Huesman for his comments before sending to Mr. Nee on behalf of Healthcare Group. Mr. Folkins didn't like 5.5B and C. Now, the significance of that is 5.6, the bottom one, is a valuation based upon the income of China Bids direct. It's a multiple of income over an average number of years. 5.5B and C say that if one member in the valuation process doesn't like the valuation reached in 5.6, you can demand an arbitration to determine the fair market value of that interest. Well, if you use the income method in 5.6, the alternative method to use in those two provisions at the top would be the book value of China Bids. What's the difference? The difference is in the bottom one, you get a valuation of $3 million. If you use book value on B and C, you get a valuation of $113,000. $113,000 versus $3 million.
And why is that problematic if it applies to both parties to the agreement?
The problematic is that it would be fair if applied to both parties. Here's the problem. When Mr. Huesman sent that to Mr. Folkins says, don't send B and C to the other side. I won't ever agree to that.
He didn't like it.
He didn't like it. And he's the one that is determining his is the value, his is the interest being valued.
Well, it is because he elected to withdraw, but it's just as true that your client could have elected to withdraw, and if they had, they would have gotten the value under 5.6, right?
5.6, or it would have been 5.5, but it would have been fair to both sides. And it was the duty of Mr. Huesman as the attorney, as the fiduciary, to explain that alternative to both sides. He didn't do it because after he determined that Mr. Folkins didn't like 5.5 B and C, he sent it on, he deleted those provisions from the draft and sent it on to Mr. Nee for his signature. Now, that, given the fact that a motion for summary judgment was granted, means that there was no determination of an issue of fact. When that transaction is looked at, you've got a breach of fiduciary duty that involves a presumption of the invalidity of the transaction. That in and of itself creates a question of fact. So we have a question of fact with respect to fraud in the inducement. We also have a question of fact with respect to the material misrepresentation that was made when it was submitted to Mr. Nee for signature. When Mr. Huesman submitted this draft, he said in a memorandum, oh, this draft is no different from the prior drafts. First of all, he said this is a standard agreement after taking out B and C. He represented it was a standard agreement. And then he said, this is no different from everything you've already signed in a prior operating agreement. Well, guess what? There was no buyout provision in the prior operating agreement.
Didn't he also, though, in the emails specifically set forth the provisions where changes had been made and specifically referenced 5.6? And if that's true, what obligation did your client have to read the document?
No obligation, Your Honor, because it was given to him by counsel for the company and for counsel for the members, and he had a right to rely upon, and that raises a question of, which Your Honor asked, was that reliance reasonable? Which in and of itself is a question of fact. So that and the cases that we've cited to the court, and the case relied on by the trial court, specifically say that if fraud is involved in the execution of the agreement, that vitiates the need to read. That's in the Denley decision. So that if you've got fraud over, if it's a standard agreement between two parties over the warranty of an air conditioning unit or something like that, and you don't read it, that's too bad. You put an attorney in there that's supposedly representing the corporation and the both members of that limited liability company, and he makes these misrepresentations. I'm sorry, I think the jury is entitled to determine whether or not his failure to read, and he did rely on it because he did say in his deposition, I'm relying on the fact that the company attorney has made this recommendation to us. So I think that raises an issue of whether or not, at least a question of fact as to whether or not his failure to read was reasonable, precluding therefore a grant of the motion for summary judgment. So that we've got both issues of fraud. Accord and satisfaction was the other defense that was raised to this breach of contract claim. There, the defendant, Healthcare Group, made a motion prior to trial that said there is no issue on accord and satisfaction. The agreement is very clear that it shows that it is an accord and satisfaction, and it states that agreement. Let me back up just a second because I've assumed some knowledge which you might not have. After the operating agreement was executed, the parties executed a stock purchase agreement by which Mr. Folkins sold some of his stock to Healthcare Group for $1 million. And this was in September, it closed, the transaction closed in November, and this was some 8 to 9 months after the operating agreement itself was signed. But the parties intended that to be an accord and satisfaction. Healthcare Group thought it clear enough to make a motion, affirmative motion for summary judgment, because the provision of the stock purchase agreement for that $1 million worth of stock specifically said this agreement contains the entire agreement between the parties regarding the sale of CBD ownership interest. All prior understanding, agreements, promises, and representations are of no force and effect. And the operating agreement was the prior agreement that we submit was referred to in that. That motion for summary judgment made by Healthcare Group was denied. The court specifically said, we find as a matter of law, there is a question of fact concerning whether or not this was intended by the parties to be in accord and satisfaction. We say it's clear, but nevertheless the court denied that and we went to trial. On the first or second day of trial, a statement was made about accord and satisfaction in opening statements, and an objection was made. A bench conference followed during that day and the following morning. Without the filing of a motion, without the hearing on a motion, the court ruled that accord and satisfaction would not be available as a defense to Healthcare Group. No, I want to say that again. No motion for summary judgment was filed, and yet Healthcare Group was precluded from being able to offer any proof whatsoever on the issue of accord and satisfaction, which would have been a complete defense to a claim under the operating agreement. We submit that is grounds alone to reverse. I see I'm down to 1 minute, so I'm going to turn this over to Mr. Lewis for a presentation on his issues.
Good afternoon, Your Honor. May it please the court. I'm George Lewis, now of the Knoxville Bar, and I represent James Nee. And it's my hope to discuss with you in the 14 minutes that I've reserved 3 primary issues: punitive damages, piercing the corporate veil, and the lack of the causation element in plaintiff's cause of action for tortious interference. I'm going to begin with an issue I wish I didn't have to begin with. We filed a motion in this case asking that the court remand the case to the trial court for the making of a record on what circumstances led to adversary counsel representing to the court that one of his jury charges was, quote, straight out of the TPI when it was not. That jury charge, this is in our brief, of course, that jury charge is 1455A. It was represented by Mr. Patrick to be, quote, straight from the TPI. The TPI says that a jury may award punitive damages. The charge submitted by counsel said, quote, if you find any of the defendants acted intentionally or maliciously in their actions towards plaintiff, you should award punitive damages towards plaintiff. That's volume 50, transcript 3027 through 28.
And my question to you is, what obligation did you guys have as counsel to ensure that the jury instructions correctly represented what you wanted them to say?
Let me address that generally, Your Honor, and then specifically with respect to this circumstance, if I may. This court decided Poteet, and the middle section decided Malibu. And in my view, those cases stand for the general proposition that although it's better to raise it contemporaneously, it's not a waiver of the issue on appeal as long as it's raised in the motion for new trial, which this was. But I say something else, Your Honor. I say all those rules about waiver, do you need a contemporaneous objection or not, go out the window when counsel has misrepresented to the court the nature of the charge. Let's look at what they told you in their brief. When Judge Hedrick asked the Appellees attorney whether this instruction was indeed directly from the TPA, they informed him that it was, and the conference proceeded on to other topics. It's hard to waive something you never knew about. And it's hard to waive something that, frankly, a misrepresentation was made.
But you knew what regardless of whether it's verbatim from the TPI, I mean, you knew what the language said that was going in front of the jury, and if you didn't like the language, and that's ultimately the issue, right? It's not really, does the TPI say this or does it not? The TPI are suggestions, they don't have to be followed, but if you saw it and said, you know what, that doesn't sound right to me, did you, even if they misrepresented that it came from the TPI, did you not have an obligation, I mean you general, not you specifically, but to say, I don't like this language and I have a suggestion for something that more clearly represents what is actually the correct instruction?
You use the word obligation. If obligation means failure to do so waives the right to raise that issue on appeal, I would submit to the court that's not the law as represented by Court of Appeals decisions in Poteet and Malibu. That's just not required. I will say, not that you should be moved much about this, but I think that's the right rule. Because I think there are plenty of motivations to raise it contemporaneously, but I also think, and this trial is a perfect example, they were in an awful big hurry when they were trying to do this, and that's in the record, okay? And so they're in a hurry to do all of this. They have a month to reflect on it and think on it, and they raise it. And you want that trial judge, it seems to me, for your benefit, to have the ability to fix that error at the MNT level. As was said in the introduction to that company brief, it's a very interesting observation because we have it over and over, this failure to make a record that would allow you to review these issues. It happens over and over again. It happened with judges' issues. It happened with Vail. It happened with punitives. It happened with the tortious interference. Would you please just tell us why you're ruling the way you are? And so I think this court could write a very instructive opinion on these types of issues. Let me tell you another reason this punitive damage verdict shouldn't stand. And that's the General Assembly passed a statute, 2939-104. It's the punitive damage statute. It's the one that was involved, sat in this courtroom and heard the damage cap litigation argued. Well, Section 1 says, punitive damages may only be awarded if the claimant proves by clear and convincing evidence that the defendant, singular, against whom punitive damages are sought, acted maliciously, intentionally, fraudulently, or recklessly. 4, in all cases involving an award of punitive damage, the trier of fact in determining the amount of punitive damage shall consider, to the extent relevant, the defendant's singular possessive financial condition, the defendant's singular possessive wrongdoing, the defendant's singular possession conduct, and what impact it had, over and over and over again. It's singular defendant. The General Assembly conferred a statutory right when it passed this statute. I was interested in that first argument when she talked about being deprived of the benefits of the statute. Our clients were deprived of the benefits of this punitive damage statute because the trial court continually conflated defendants over and over again. And so we didn't get the rights that were confirmed to us by the General Assembly in 2939-104. A couple of other things. This is all in the brief, but of course we have compensatory verdicts against one party, or for one party, bed boss, and punitive damages on the same theory for Mr. Folkins. By the way, on the business of being in a hurry, volume 49, 29, 59, and 2933 talks about rushing, struggling, page 126 of the same volume, and speed, volume 50, when he's talking to the jury. I've done everything in my power to speed this case along to make sure we didn't run into issues, but we do need to conclude this phase. Well, that caused lots of problems. The conflation of these defendants together caused lots of problems. Let me go to this chart and talk about the piercing of the corporate veil. If I don't get anything else across about this issue, let me get this across. China Beds Direct, right? Those are the distributors that are selling the product that they're complaining we interfered with. China Beds Direct is composed of two members. It's an LLC group with 55% and Ben Folkins with 45%. You notice who doesn't own any? My client, Mr. Nee. See, group, Mr. Nee doesn't own any of that either. Wholly owned by company. And company is a publicly traded corporation on a Chinese stock exchange. And we gave you a couple of pages in our brief of all the regulations and procedures, and they have to have a shareholder officer before they buy and sell stock and all of this. The only thing he owns, or the stock he owns, publicly traded. So in order to reach my client, this contract, this breach of contract, the first thing that you're doing is hitting him for a contract in which he wasn't even a party. Next thing you're doing is piercing through a corporation in which he owns no stock. And the next thing you're doing is piercing again another corporation which is publicly traded in the country of China.
Mr. Lewis, was there any evidence that Mr. Nee sort of treated all of these companies as one and the same, his companies, shared employees, that he didn't really distinguish between the corporate formalities?
Here's the test, Your Honor. I think you're referring to the Continental Bankers test. That's the parent-to-parent test. Allen is the corporation to shareholder test. And here it is. At the time of the transaction complained of, must exercise complete dominion over its subsidiary. I cannot find proof in this record, any proof in this record, of that element. The control must have been used to commit fraud or wrong. Well, we've got fraud allegations that never got reached, but we don't have fraud on the part of Mr. Nee in conjunction with the contract. And then the control and breach of duty must proximately cause the injury. And this court reaffirmed that all three of those elements are required, and that's your decision in Uray versus Recovery House of 3 weeks ago. If you read, if you run the argument they made on piercing the corporate veil through word search, you cannot find the word causation in it. They just forgot that element. It's not there. And if that wasn't bad enough, we've got a jury verdict form problem again. This will lead to our colloquy, of course. But we do have a jury verdict problem because when it came to piercing, they said, who's responsible through piercing? Is it this man or these two corporations or all of the above? No,
Now, how do
none of the above.
how do you get out of the waiver argument on the verdict form when there's no alleged misrepresentation? It was just a verdict form that was agreed to by all parties.
Well, the verdict form reflects those problems, but again, Your Honor, I just don't think that Tennessee law requires that to raise the issue on appeal. Is it better for parties to raise contemporaneous objections to verdict forms? Yes, it is. But does it mean that you can't correct an error raised in the motion for new trial? This court has so held twice. No, it doesn't mean that. And these were errors. So I understand the court's frustrated that they weren't identified contemporaneously, but the law
I don't know
is
that I'm
that they can still
frustrated.
raise
I'm
it.
just asking.
Well, I know, I have a feeling Your Honor would prefer that they be raised contemporaneously, but the law, this court has taken a look at that issue at least twice and decided that we're not going to require that. We're going to give those trial judges a chance to fix those instructions first. All right, let me move to interference, unless the court has other questions. Another thing I want the court to understand is this. These three distributors, these are not distributors we were trying to take away from them. These are distributors that are existing distributors of China beds. Mr. Folkins is asking that they leave to go with him, right? And here's what they said. The three of them, they limited themselves to three distributors. Mr. Sweeting testified he began having problems with Folkins before Folkins cut ties with China beds. Sweeting explained that due to other decisions Folkins made, Sweeting's business went from 450 customers in 2015 to 62 in 17. That's one. Number two, LaMontagne testified he wanted to maintain his M. Lily business. That was a brand that they had that they liked with China beds. And after he was shut out of ordering M. Lily product from Bed Boss, he committed to M. Lily because he wanted to maintain his distributorship. That's record volume 45, transcript 2261. That's the second one. The third one, Windsor testified that he preferred China Bed's superior branding and the financial support the company provided. He also testified regarding his frustrations with Folkins' business dealings and his concerns. So this is not a situation where we're weighing evidence. This is a situation where there isn't any showing causation. I feel like I want to talk about this problem with this jury instruction again. I want to know who did this. I want to know, did this lawyer or this lawyer or this lawyer do it? What did they do? How did it happen? When did it happen? When did they figure out it happened? And why haven't under Rule 3.3 they come before this court and explain what happened? Because I think that issue could pretermit every single issue in this case. This court's been reviewing trials for 98 years. They're established by the legislature in 25. Never been afraid of righting an injustice when you saw one, and I hope you won't be this time.
Thank you, sir.
Good afternoon. My name is Gary Patrick. I represent the Appellees in this particular case. And Ms. Ladico informed me that I would reserve a couple of minutes, 2 minutes for her at the end to talk about the interference claim. But Mr. Lewis raised the jury instruction first. So let me get to that issue right off the bat. Throughout all the jury instruction, let me point out, first of all, he was not involved in the trial, so he may have forgotten this. He only got involved in the appeal. But the jury instruction issue was raised for the very first time in this case, on this appeal, in this court for the first time. It was never raised in a jury, in a post-trial motion, period. But despite that, with respect to almost every one of the jury instructions, you go by the TPI, and then at the end, you make those jury instructions applicable to the particular case. For example, when it had the definition of operating agreement, definition of a contract, it gave the TPI. Then it says if you found that there's been a violation of the 2016 operating agreement, then you will find in favor of Ben Folkins. That's what it says. So throughout the whole jury instructions, so they could not overlook this. I mean, that was out throughout the all the jury instructions. But here is the very interesting part, is that when the judge, I'll back up. We submitted our jury instructions on July the 20th. The trial started on August the 3rd. Any objections to jury instructions or jury verdict form were to be submitted before the final pretrial. And there were no objections to the jury instructions, no objections to the jury verdict form. We had a conference the night before the case was submitted to the jury. And we talked about the jury instructions the entire time and the jury verdict form. We probably spent 3 hours just on the jury instructions and the jury verdict form, and that continued into the next morning. When the judge read the jury instructions before closing arguments. And he read all the jury instructions, and then we were going to have closing arguments. The jury had a 10-minute recess. Mr. Lamonaco stood up and said, Your Honor, we have an objection on 2 jury instructions, the indemnity agreement and the punitive damages. We want the indemnity language, which is the attorney fees language. We want that to apply to both parties. And likewise, because we had filed a lawsuit asking for punitive damages against Mr. Folkins, we want the punitive damages award to apply against the instructions to apply also in our favor. And the judge said, you had the responsibility to get me those instructions before this time, and you failed to do it. Nevertheless, I think your request is reasonable. And so when the jury came back in, what the judge did was that he said and read the indemnity paragraph again and said, attorney fees, either side can get attorney fees, either party can get attorney fees. And in fact, when the jury later came back and made the decision, they did award attorney fees against healthcare group. And so
let me ask you this, Mr. Patrick, because Mr. Lewis's point is a fair point. I mean, it's one thing to stand up and say this instruction comes straight from the TPI. That would lead one to believe this is a direct quote from the TPI. If in reality it's been modified, like in my experience, you would typically stand up and say, it's TPI number da-da-da-da-da with some modifications. In fact, when I did jury instructions, I would even put that in parentheses, modified. So what is the effect of not clarifying that?
Sure. In this particular, Your Honor, it was obvious that at the very end, whether it was for the defendant or for the plaintiff, that after the quote, after the TPI was given, and then it was made applicable, just like I said, if you find a breach of contract, then you would find you'd find in Ben Folkins' favor. The jury instructions were for the defendant the same way, but this is what happened with this particular jury instruction. What the judge said, that is fine. So the defendants asked, the appellants in this case, asked that jury instruction, the same jury instruction they're complaining about now, be given in their favor. And the judge did that. The judge reread the entire punitive damages section, and this is what the judge said when he reread it to the jury. He said, if you find that any of the parties for either side acted intentionally or maliciously in their actions toward the opposing party, you should award punitive damages, making it equal to both parties. at the request of the defendants. So the defendants are the ones that requested this particular jury instruction to be given for them. That's in volume 49, page 3040, lines 1 through 4. It's very clear. They asked for this exact same jury instruction to be given to the jury for their benefit because they had also sued for punitive damages. Then on top of that, they never raised this issue in any post-trial motion whatsoever. The first time it was raised was in this court. So I want to address that right off the bat. So this is something that truly they have asked for the same jury instruction as we did. I would like to just give this court a little bit of background about the facts of the case, and then I want to address the fraudulent misrepresentation issue and the accord insatisfaction issue, and then the piercing of the veil issue. Mr. Folkins began a mattress company in Tennessee, actually in Cookeville, Tennessee. He had a real gift for designing mattresses. And in fact, he started a company called Upward Mobility, DBA Bed Boss, and he actually sold the mattresses through a line of distributors throughout the entire United States. Zhenjian Ni had a pillow company in China, and he had just begun to get into the mattress business. And in 2009 and 10, Mr. Ni started talking to Mr. Folkins about, would you design a mattress for me and sell it in the United States? And after a lot of discussions, in fact, that did happen. They entered into an agreement, and that's China Best Direct. And Mr. Folkins used the distributors he had built up to sell the mattresses for Zhenjian Ni's company, healthcare company. And they sold them throughout the entire country, and literally, very quickly, was selling tens of millions of dollars per year, and it built up to $100 million or so several years later. But in 2016, Mr. Ni took his company, healthcare company, public, even though he maintained the majority interest in this company. He took it company and sold it. And when he did that, he started putting pressure on Mr. Folkins for more profits, more sales, and he also started selling knockoffs directly to retailers, not going through the distributors, which made the distributors obviously very upset. So in late 2016, Mr. Folkins informed Mr. Ni that he would be withdrawing from the company. But he said, I will stay with the company for 10 months to make sure there's an orderly transition. But after Mr. Folkins sent Mr. Ni that email, Mr. Ni would communicate with him whatsoever. Would not accept his phone calls, would not communicate with him by email, would not meet with him despite Mr. Folkins' request. But what Mr. Ni did, he flew to the United States and met with several of the distributors that both Mr. Folkins' company and the M. Lilly brand used. And this is what Mr. Ni told to those distributors. He said that Mr. Folkins had embezzled money, which obviously he had not, and there's zero proof of that. He said that Mr. Folkins was a criminal. He said that Mr. Folkins was going to jail. He said that if any of you do business with Ben Folkins again, you can never buy from healthcare company again. And he said that I'm going to ruin Ben Folkins, and in fact, he did do that. Mr. Folkins at that time immediately withdrew from China Best Direct and requested that Mr. Ni comply with the operating provision concerning withdrawing of a partner, which I'm going to discuss in just a minute. Paragraph 5.6 provided for a formula that applied equally to both healthcare group and Ben Folkins. Ni refused to comply, and then that's when Mr. Folkins filed this lawsuit over 6 years ago. In a sworn answer to this complaint, Mr. Nee denied he ever signed the operating agreement, which I'm going to discuss in more detail in just a minute. Not only that, in answers to interrogatories, under oath, of course, he again swore under oath that he had never signed the operating agreement. After about 3 years of litigation, finally proven that he did sign it. And then that's when they pivoted to this fraudulent inducement, fraudulent misrepresentation, accord and satisfaction defense. So here's the defendants saying that on the first hand, it was fraudulent. There was fraudulent misrepresentation why he entered into it. But for 3 years, under oath, he took the position that he never even signed it. But here is he testified he never read the operating agreement. He testified that the only misrepresentation that he was relying upon is in an email. This is an email from the company attorney, John Huseman. And let me just stop there just for a second. Mr. Huseman did not represent Ben Folkins ever. That is simply not correct. That is stated in their brief, and it's stated also in the reply brief, but that's not the case. Mr. Huseman specifically testified, and I'll give you the volume number for the record. He specifically testified that he had never represented Ben Folkins. And that's in response to a question that Mr. Flores asked him. And that is at volume 63, page 47, lines 22 through 24. And in response to a question, did you represent Mr. Folkins personally? Mr. Huseman said, no, I never did. So he did not represent Mr. Folkins personally. He represented the company. But here's what the defendants are saying is the misrepresentation. They say the misrepresentation is contained in the email that sent the operating agreement. And the misrepresentation is this. They say the email says this is a standard provision. That's what he says. But their own expert says, no, that's not what this email says about paragraph 5.6. They've taken it down.
Let me ask you about the defendant's expert, which was Professor Cuny. Y'all both sort of referenced that, but that testimony was not presented to the jury, correct?
That's correct.
Okay.
That's correct. It was not. But it's easy to read paragraph, what the email says. The email is 1 page long, and the email it says paragraphs 5.1 through 5.3 are standard. And so there's reference in there to standard provisions. And then it says 5.4 does this. It says 5.5 does this. And then it says 5.6 deals with a buyout provision of a withdrawing partner. One statement. It does not say it's standard. But that's what they're saying all this fraud is about. That's what the point is. But it's even better than this, that Mr. Nee testified he never even read the email. I mean, he says he never read the email. Hold on 1 second. I can give you that volume number maybe in a minute. I'll keep going. But it's in our brief that he never read the email. What he says, he relied upon his team to tell him, and he says his team, whoever his team is, said it was standard. But that's not what the email says. The email is black and white. It says 5.6 deals with a buyout of a withdrawing partner. So, but we have Mr. Nee, who testified under oath for 3 years that he had never that he had never signed the operating agreement. And now then he pivots and says, oh, well, I did read it, but I did sign it. But there was a fraudulent misrepresentation in it. And then that's based upon the fact that he never even read the email. So that is contrary, and that's why the judge ruled that paragraph 5.6 is valid and binding, and that's why the judge kept out all of the former drafts, which are clearly parole evidence. So there is no mistake whatsoever. There is no fraudulent inducement. He has a duty to read the contract. I will now talk about accord and satisfaction. Look to that. In accord and satisfaction, I'll back up. So, Mr. Konvalinka was involved in this case for a while too, and then he got out. But when he got involved, after 3.5 years, he came up and filed a motion for summary judgment on merger and integration, saying that this purchase agreement, I'll back up even further. In September 2016, Mr. Nee purchased 10% of Ben Folkins' stock. Ben Folkins owned 45%. Mr. Nee paid $1 million for 10% of that stock. That left Mr. Folkins with 35%. If you just follow the math, that would be 3.5. The jury found the formula in this agreement was 3.1 million, almost identical to what Mr. Nee voluntarily paid to Ben Folkins. In this purchase agreement, it specifically says that he is buying 10% of the stock. It doesn't say that this replaces the operating agreement. This amends paragraph 5.6. It doesn't say that whatsoever. But what it does say, attached, that's Exhibit 30 it's a trial Exhibit 30, attached the very next page, and that was entered into on September 21st, 2016. The very next page is a resolution authorizing the purchase and amending the operating agreement. And it amended the operating agreement in paragraph 4.2. It says paragraph 4.2 is amended. That paragraph dealt with distributions of net profit to the members. It never amended paragraph 5.6. Yet their position is that, oh, this was integrated, this was merged, this is an accord and satisfaction. It is not there. It is simply, you look at the document, you look at everything, it is simply not there. And that's what the trial judge found as a matter of law. I think the next issue that they came up with were punitive damages. And I think that's a pretty quick argument. With respect to punitive damages, the jury was given the instructions, and you can tell from what I've said that a witness actually testified at trial about all those things I just said, with what Nee said and how he was going to ruin Ben. And the jury found punitive damages. And punitive damages, it doesn't violate the statutory cap, because punitive damages can be assessed on double the amount of compensatory damages, which can be contract or tort. And that's particularly what happened in this case. And there's not an issue. I mean, I'll go back to the jury instruction again. It wasn't as if the jury was on the borderline of whether they would give punitive damages. During the punitive damages part of it, I had requested, after the proof was in, that the jury award $10 million of punitive damages, despite the fact that Mr. Nee, the proof was Mr. Nee was worth at least $500 million, not $500 million. And the jury came back, even though I asked for $10 million, the jury came back and gave us $20 million. So the jury saw what had happened. They weren't on the fence about punitive damages. They had heard Mr. Nee testify probably for at least a day, maybe more than a day. They had heard all these facts. They knew exactly what had transpired in this particular case. Now, with respect to, And the judge reduced the punitive damages. I'm sure you see from the record, he reduced it down to twice the amount of compensatory damages. With respect to, and I'll tell you one more thing, healthcare company never raised the issue of punitive damages, they did not have an issue on punitive damages in their statement of issues in this particular court. They adopted Nee's arguments in his brief, but they did not adopt the statement of issues. You look at the brief, that's the first brief I saw. When I got that, I said, my goodness, they don't even address that. They don't raise any punitive damages whatsoever in their statement of issues. With respect to piercing the corporate veil, we gave there were some specific jury instructions on piercing the corporate veil. And there were 2 jury instructions. One, how do you pierce the veil from a subsidiary to a parent? That standard is different than you piercing it from the parent up to a shareholder. When you pierce it from the corporation to the shareholder, you really look at the Allen factors. When you pierce the corporate veil from the subsidiary to the parent corporation, you have to determine it was their dominion and control by the parent over the subsidiary that worked in injustice that caused the damages in the case, and what are their damages. And in this particular case, one of the best examples of all is the operating agreement itself. So the very first paragraph of the operating agreement says, and the very first sentence says, the parties signing this operating agreement are the members of China Bez Direct. And it doesn't identify anything. You go to the signature page, Ben Folkins signed it, Zanjin signed it on behalf of healthcare company, not group. He didn't sign it on behalf of group, he signed it on behalf of healthcare company. The stamp, the corporate stamp there for healthcare company is on the signature page. So that's just one of the many factors. Ben Folkins and Andrea Folkins both testified they never knew anybody that worked for group. They never had any communication whatsoever with anybody at group. They didn't even know an office existed. Apparently an office exists at group. But of all the motions, multiple motions we've had, and during the trial, there was never a representative of group at any of the motions, nor at the trial, period. The Folkins dealt with Zanjin Nee the entire time. There was the only veil that had to be pierced for a parent from subsidiary to company was from healthcare group going up to healthcare company. And then was Zanjin Nee also liable under the Allen factors? And the jury found that he was, after all the proof. We cited, I guess, we probably took up 10 pages in our brief, and we cited 28 different factors, and that's just some of them, 28 different factors of how these companies were commingled and confused the entire time, and the jury clearly found that. Let me see what else I need to address that Mr. Lewis raised. The jury verdict form, let me address that just briefly. They maintain that the jury verdict form is a little confusing, the jury didn't know what they were doing because they found all 4 of the defendants had acted intentionally or recklessly with respect to Ben Folkins. And then on the jury verdict form, it says, what is the award? And there's a handwritten note on there, healthcare company and Zanjin Nee, $20 million. And they said that's internally confusing, it's inconsistent. That's not what happened. What happened at the trial, because Zanjin Nee had caused China Bez Direct to transfer all its assets out of China Bez Direct to another company called M. Lilly USA, Inc. All the employees, all the inventory had been transferred out of China Bez Direct. And he testified about that in his deposition and at the trial. We had an employee testify at the trial that all the inventory he had been selling for China Best Direct, he was now selling for M. Lilly USA. All the employees were the same, that he considered them one and the same company. This was the warehouse manager at the time of the trial and during the whole time. So obviously, without any assets in China Best Direct and without healthcare company, we didn't have any financial information on them. As far as we knew, Group only owned China Best Direct, and without any assets in China Best Direct, it had no money. So there was no proof to put on. So we announced before the trial that we were not seeking punitive damages against Group and China Best Direct. What's the point? We don't have any financial information. They don't have anything. And so we're only seeking against healthcare company and Zhanjian Ni. The court specifically instructed the jury, you're only looking at Zhanjian Ni and our healthcare company. Write the name of the defendant if you found that either one of them are liable for punitive damages. Write them on the jury form with the amount. The jury followed the court's instruction. That's exactly what they did. There was no internal confusion whatsoever with respect to the jury. I'm going to save the rest of the time for Mr. Ledico. Is this my time or the total time?
Should be total time.
Total time, okay. I'm sorry, Mr. Ledico.
That was the total, okay. I do have 2 minutes, or that's their rebuttal?
No, you got 2 minutes.
Okay. May it please the court, Susie Ledico of the Chattanooga Bar. I represent with counsel at the Appellees table, Ben Folkins and Upward Mobility. I am only going to be speaking to the argument related to interference, intentional interference. Mr. Lewis argued this afternoon that there was no evidence of causation. He referred to 3 distributors who testified at trial. In their briefs, they said that this is direct evidence of no interference. We argued that actually there was quite a bit of circumstantial evidence and perhaps some direct evidence of the causation of damages as a result of interference as well. I just want to first point out that it doesn't matter if it's direct or circumstantial. Tennessee law does not care if it's direct or circumstantial, and we've cited cases to that effect in our brief. But as Mr. Patrick pointed out, these 3 distributors testified. They were cross-examined. The jury heard their proof and their testimony, and it was clear on cross-examination that all 3 of them were substantially indebted to Mr. Ni and his companies, and all 3 of them relied on Mr. Ni and his companies for their livelihoods. So clearly, that would be evidence of bias. The jurors also heard from a gentleman named Stephen Todd, a distributor that we called on our behalf. Stephen Todd testified that there were several meetings after Mr. Folkins withdrew where many of the distributors were told all of the things that Mr. Patrick summarized for you. Mr. Folkins is a criminal. He's going to go to jail. I'm going to ruin him. And then in addition to these meetings, there was a February 7 email sent to numerous distributors authored by Mr. Ni, saying that Mr. Folkins was the reason that China Beds was not able to get product. He had mismanaged it. And also, Your Honors, we are asking for attorney's fees on appeal pursuant to the indemnification provision. I think I'm out of time.
Okay. Yes, sir. Your rebuttal.
Yes, Your Honor, may it please the court, I will handle rebuttal. Mr. Patrick said I might not have remembered something because I didn't try the case. He might not remember something because he did try the case. Because this email that this lawyer sent says all terms and provisions are either standard American LLC company provisions, and then in Article 8 of the email he says standard provisions that provide for the orderly operation of the company. So I think he did take that representation. Did you notice what you didn't hear anything about? One of these lawyers inserted that sentence into the TPI. They either told Mr. Patrick and he forgot, which is what their original story is, that he inadvertently forgot to tell them, or they forgot to tell them and they told him later. Now, he's just stood up here and I watched for 5 minutes. He said that we waived it because we didn't raise it. Well, we didn't know about it because they didn't tell the truth about it. We found that out later. So I say, Your Honor, you can raise those issues if you raise them in the MNT, but I say all bets are off when you've got a misrepresentation like this. Think
Was
about
that
the
issue raised
implications.
before, Mr. Lewis, was that issue raised before the trial judge?
We were trying to do that when we filed the motion to remand with this court, to have it remanded to the trial judge for a hearing to determine these facts. And the court declined us having that hearing and just told us to brief it and argue it, which is what we're doing now. But this was all discovered after the motion for new trial was argued and everything. We were looking at the record and noticed that he had represented that it was straight from the TPI, and looked at the TPI, and that sentence is not there.
Did you all use the same instruction on your claim for punitive damages?
I don't know the answer to that.
I bet the record will tell me, but
Yeah,
I just wondered if you
I
knew.
suspect so. I'm out of time. May I make one more point?
Because 30 minutes is not enough.
You know, we should have asked for an hour on this one, Your Honor, probably. Please watch for the element of causation in every single issue I have. It's pretty obvious that that's not there, and you didn't hear anything about it in the argument.
We want to thank both sides, the attorneys, for your presentation. We will look at this very closely, and you should receive our opinion and judgment within, I normally say a reasonable period of time, but this may take a little while. But you will receive our opinion and judgment, though. Thank you. The lawyers may be excused.